Okay, this is a question we get all the time, and I run into it all the time. People think that they have to go to a title company to close an owner finance transaction. Do you have to go to a title company, or do you just go to a law firm?
Or do a kitchen tabletop closing, right? So never do a kitchen tabletop closing. So first off, guys, what you have to understand is a title company can only close a transaction if title insurance is being issued. So you go back to the two simple questions. If you're buying the home, do you want title insurance? I bought a home subject to the existing debt. I had almost $100,000 cash tied up in the transaction. I did not get title insurance. That's me. Some people might feel that's a little bit too risky and they want title insurance. Fine, you get it. In that case, you close at a title company. If not, you're going to close through a law firm. When you're selling a home to a home buyer under any type of creative finance, whether it's just a straight on finance or a wraparound mortgage, you let that buyer decide. And if the buyer wants title insurance, we can still close through our law firm, and we'll simply order the title evidence for you in that instance. And so really it comes down to whether or not title insurance is going to be involved. If it is, you're closing you can close in the law firm or title company, either way. But 98, 99, probably 99.4% of our closings never have title insurance.
Okay, but do you do some kind of a search for liens, or?
We will always do, at bare minimum, a title run in a name search or an abstracted title on every transaction.
So nothing pops up. Okay.
We do our best.
Okay. The next question is, what paperwork should I get from a seller on the first meeting?
So what am I doing?
We're going out and we're calling on somebody in pre-foreclosure. What paperwork do we need to get in that first meeting?
Well, first off, I want to know the situation and what's going on and what's happening. That's the first thing I want to know. Secondly, I want to know, what's their position. No, if it truly is a pre-foreclosure, there's going to be paperwork from an attorney, right? We want copies of that paperwork. Two, I want to see their most recent mortgage statement. Now, if they're in a foreclosure, most mortgage companies cut off sending mortgage statements several months prior to that. So you might get a mortgage statement that's 1 or 2 months old. I'm trying to get everything I can, mortgage statement, attorney information. While I'm there, can I get a copy of the seller's existing note and deed of trust? Can I get a copy of their insurance policies? I need that loss payee term.
Right.
But I want to know those kind of things. I want to get all that right there. Get as much as you can in that first meeting.
Okay. This is an interesting question. Should I file my contract in deed records? And why should I or why should I not?
So unfortunately, Susan, the investor marketplace can be cutthroat, right?
Yeah.
And I've actually had a situation where we had a property under contract. We were prepared to close it the next week, and on Saturday, another investor comes in, buys the property, files a deed, and the lady moves out of state. What are you going to do?
But
are you going to try to sue somebody who doesn't live here anymore, who has no money anyway?
So she signed with you, and then she signed with somebody else.
That's right. And again, that's a breach of contract.
Right.
That's probably fraud or other things of that nature, but it happens.
Right.
A lot of investors will file a memorandum of their contract as a protection mechanism because, again, investors try to talk sellers out of a deal somehow, sometime.
Yeah.
And if you're dealing with a seller who's in distress, they're looking for a way out. And that's all they care about. They aren't going to talk to a lawyer. They're not going to talk to anyone else about this. And they may sign multiple contracts. I see it happen often.
Really?
And so that first investor, if they do file their contract, they may be protecting that instance. Now, I got to make a comment though. One thing I see so much of out there is where the investor meets with the seller and they get the seller to sign. But the problem is maybe they get only the husband to sign, but there might be an estranged wife, or maybe a divorced wife, but a deed hasn't been conveyed. Or maybe it was an estate scenario. There might be multiple heirs. They get one heir to sign, but not everybody. And then of course the question becomes, did that heir ever have the capacity to sign the contract? So we're always asking questions, just like that last question, what do I need to get? When we're meeting that seller, we're asking questions to discern the situation.
Okay, so in the end, do you file in deed records or you don't?
I think it is an individual choice in that instance. Do you trust your seller? Do you feel confident in the transaction or not? Are they seeing a lot of people? No, we go out on various properties and it's a cattle call. You know, there's 100 other investors there.
Right.
I just assume walk away in those scenarios. But each case is going to be different a little bit. So I think it's as the investor feels most comfortable in those situations.
Okay. How much does it cost to record that?
Well, a memorandum of contract?
Yeah.
Well, here in Texas, it's $26 for the first page and $4 for every page thereafter.
Okay, so say you have that, and then they sign with somebody else, then what? Just because you have that, so then the other people it's null and void?
No. What happens is that the memorandum of contract may only be 1 page long. I like to attach a copy of the contract to that as additional evidence and support.
Okay.
Now that becomes a cloud on title. It's not necessarily a lien, but it's a cloud. It puts the world on notice that there's another contract that's valid that might be prior in time to the new contract. So for instance, if I put the house under contract and record my contract, you then come in behind me like the shifty person you are, and you get another contract out there, and you try to go to the title company and close it, they're going to pull up my contract and go, we can't close this, it's cloud on title. You need to go back to Scott and get them to remove their contract.
Okay.
So the question that's going to become is, do I have a valid contract signed by all the right people? Did I put up reasonable earnest money? Not $1 or $10, but reasonable earnest money to support my contract.
Okay.
And then maybe you have to negotiate with me or not. And at that point in time, Susan, if I know this is going on, and this is a house I really want to buy, I might go to that seller and say, look, either we get this done right now, or we're going to file a lawsuit for what's called specific performance, which is forcing that seller to sell me the home. I don't want to do that, but sometimes you may have to do that.
Or you can negotiate with the shady investor and say, pay me $10,000 and I'll give it to you.
Anything's possible at that time.
Okay. If you are using a bank to buy a property and I want to sell it with owner finance on a wrap, should I tell the bank?
Absolutely. I think whenever you are borrowing money from any lender, they need to know what it is you're doing. Now, if you're buying a home subject to, here in Texas, there's a requirement to notify the lender. We have our buyers and sellers sign off on documentation agreeing not to do that, though, because that lender is either going to do nothing or tell you no. But if it's a commercial bank, private lender, something down those lines, I want my loan officer to know exactly what I'm doing. Most small commercial banks like this business because they know that I'm liable in the debt, and if I sell you the home, Susan, that gives them a secondary source of repayment if they wish to work with you. And so they like that. So, but always tell your banker what's going on.
But that's the small commercial banks that we work with. What if somebody was going to a Chase or a Wells Fargo? Would they want to set that off? No.
Because they're not going to do business with small investors.
Okay. We know that, right?
We know that.
Okay. Can we set a prepayment penalty? Say you ink a deal and you know that a month later they're going to refinance. Can we say the prepayment penalty is 1% if you finance within the first year?
Sure you can.
You can.
So.
And what's reasonable?
Well, you can always charge a reasonable prepayment penalty. Now, you got to pull back and go, there's the investor world, there is the consumer world, okay? In the investor world, you can charge probably higher prepayment penalties. I've seen 1 year of interest. But that's an agreement between an investor and a seller in that case. But if I'm selling it to a homeowner, Dodd-Frank does allow a prepayment penalty, but it has to be a reasonable prepayment penalty. So what does that mean? Does that mean 3% in the first year, 2% in the second, 1% in the third? Maybe. Can you charge them 10%? Probably not. It's not going to be enforceable. So again, if you're going to do a prepayment penalty, be smart and be reasonable.
Okay. Can we do a balloon payment?
So again, you got to determine if you are under Dodd-Frank. Dodd-Frank says, basically prohibits the use of balloon payments. That's not a bad thing out there, because too many people anticipate that they can refinance a house and they wind up not being able to do so.
Right.
And a lot of times investors take advantage of that. So if you're not under Dodd-Frank, technically you can do that. I really don't like using a balloon payment though. I don't like doing that. I think a lot of home buyers don't want to see that either. But one of the things I do to counter that is I might do a reasonable step-up loan. Let's say, for instance, we negotiate an 8% interest rate with the home buyer. Maybe I'll do 8% years 1 through 5. But after year 5, I want to go to 9%. Maybe after year 7, I want to go to 9.5. Maybe after year 9, I want to go to 10%. So what I'm effectively doing is I'm either going to make more money to make it worth my while to stay in this deal, or I'm basically going to price my buyer in a position where they need to refinance or sell the house or give me the house back, which I really don't want that.
Right.
But you're creating an incentive for them to do something.
Okay. Do we have to escrow taxes and insurance, or can we throw that back on the buyer?
Okay, so with escrow, I hate to go back to Dodd-Frank again, but Dodd-Frank basically says we need to escrow. You have to at least escrow.
Need to, or it's mandatory?
Required and mandatory to
Okay.
escrow at least taxes.
Okay.
Now, again, are you under Dodd-Frank or not? That 5 or less here rules what we believe that is, and Dodd-Frank is a national mortgage requirement out there. So one of my philosophy of those is whether I'm under Dodd-Frank or not, I am always going to escrow taxes. The reason for that is I have learned historically that's one of the biggest risks of loss that I have.
Yeah.
Imagine for a minute you own a property, you hold a mortgage, and the borrower defaults in November. You send notice, maybe you're able to foreclose in January, but you weren't escrowing. You just paid the whole year's of taxes. So I like to escrow taxes regardless.
Wow. Okay. If you have an out-of-state LLC, do you have to register it in Texas before you can buy or sell a property in Texas?
Yes.
You do.
Simple answer. Yes, you do. You cannot do business in Texas without being licensed.
Okay.
So if you are an out-of-state,
being licensed or having an LLC?
If you have a corporate entity of any type,
Okay.
you must register that entity in Texas, and you must have a Texas registered agent.
Okay. So if